Thank you all for coming, justices and ladies and gentlemen. Thank you for being here. It's a bit intimidating to be on this panel. Nitya Ramakrishnan is one of the most famous lawyers in the country. To be on a discussion with a sitting Supreme Court justice is also quite an honor and very intimidating. This first detailed report on death row prisoners in India. So, it's actually quite an historic event in that sense. I'd also like to begin by asking the panelists here, what makes this report special?
Okay, thank you much. When I was going through the report, there is a huge problem that we have in the criminal justice system. There's a huge problem. He's not brought that out explicitly, but I think if you go through the report, you will realize that the problem is really enormous and something needs to be done. I would say, 3 or 4 things that come out from this report, if you want my reaction. One is that, like I said, the criminal justice system needs a lot of reform, not only procedural reform, but also substantive reform. By procedural reform, I mean things like, the person not being able to attend the hearings, the person not being able to talk to his lawyer, or not getting advice from his lawyer, not being able to meet his lawyer. So there is a tremendous need for the accused to be able to meet the lawyer. I think this is one area which has come out very clearly in the report. Language, very, very important. Very often the evidence is recorded in English. The person doesn't know English. His statement is recorded under section 313 of the CRPC. He's asked questions. The report adverts to that. The answer is either yes or no. There are a lot of these procedural issues that need to be tackled. The time that has been taken, but the time that it takes for a trial to conclude, I think in one case it took 15 years or 20 years or something. Anyway, it took very, very long. Many people were not even given the charge sheet. Now, if any one of you is familiar with service law, and I'm sure the judges are, if a delinquent officer is not given the charge sheet and a departmental inquiry is held against him and he's found guilty, the first thing that the court will do is to quash the inquiry. How can a person defend himself if he doesn't know what the charges are? But when it comes to the criminal justice system, well, here you have, I don't know what percentage of the accused did not have a charge sheet, were not given a charge sheet. So there are these huge gaps in the criminal justice system. The second thing is legal aid. Anup has mentioned about that. I think that's one area which, I'm sorry, it's a bit of a joke in the sense that nobody really has faith in a legal aid lawyer. There are a variety of reasons for that. The legal aid lawyer sometimes has no interest. The report points out that one person said that, why are you wasting my time asking me these kind of questions, what's happening about your case? I'm taking care of your case, or something to that effect. That's the other thing which I would say requires looking at. The third really is something to do with jurisprudence. I'm not sure whether we have any philosophy, any jurisprudential philosophy on what sentencing is all about. Whether it is deterrence, whether it is reformation and rehabilitation. The report points out that if a person wants to be reformed and he's on death row, he cannot be reformed because he's not allowed to do work, he's not allowed to meet anybody else. There are all kinds of complications. So even if a person wants to reform, he can't. Retribution, is that one of our philosophies? I'm not very sure. So this is, really something which I think has come out quite clearly in your report. The fourth thing has got nothing to do with the report, but it's the fact that if an organization gets down to it, it can work wonders, like this report has shown us. It may be a law school, it may be an NGO, it could be anybody. So I think that's a very, very key thing that has come out of this report, because what we lack in the country is good, proper, empirical research, and this is what Anup and his team have done. So I would say that would be my reaction. Of course, there are so many other things he has talked about: solitary confinement and torture and so on and so forth. Some of the reasons that have come out in this report are the poor quality of legal assistance or legal representation. If the lawyer is not good enough, the chances of his being able to represent his client effectively diminish to that extent. If the accused is completely illiterate, he's poor, doesn't have any resources, that certainly has an impact on the defense that he can put forward. Then you have a system which is not necessarily very friendly. I had mentioned about translation. You're being tried in a language which you don't know. You don't know what the witness is saying. So what are you going to instruct your lawyer to ask him in terms of cross-examination? You don't even know what he has said. So you just leave it to your lawyer, and the lawyer will ask some question which may be relevant, which may not be relevant. When it comes to recording a statement under Section 313, again, the judge puts you a couple of questions, and you want to try and say something, but you cannot. So I would imagine that if a person had a lawyer who was effective, he could certainly assist the judge or the justice delivery system in saying that, listen, we need to get a few things in order. This person wants to say something in his Section 313 statement, or he wants to say something at the time of cross-examination. Let me just take instructions. So there are various factors, and certainly poverty and socio-economic factors are certainly. If you have a dozen reports like this on different aspects of justice delivery, whether it's criminal justice or civil justice, it's going to make a huge difference. So, and I'm sure this is not going to be the last report that's going to come out either from NLU Delhi or from any other place. So if we have a couple of these kind of reports, there's going to be a major change. There are two experiences that I would like to just share with you. One is that when I was in the Delhi High Court, we had started as an experiment video conferencing between the legal aid lawyers in Delhi High Court and the prisoners in Tihar jail. Initially, we had said that every Thursday or Friday or something, we would get, Tihar jail would get 20 people to come and sit in a room, and we would be told about it on Monday, so that we could get the files and we could get the legal aid lawyer, so that at least they could communicate through video conferencing. And for the first 6 weeks or maybe 7 weeks, these 20 people came, so that's about 140 or 160. And the only question that they asked was, "Meri case mein kya hua?" They had absolutely no idea what had happened in their case. They had applied for parole, they had applied for bail, so on and so forth. They had absolutely no idea. I don't know, is that system still continuing of, sorry? It is still on. Okay, and I'm sure over the last 5 or 6 years or 7 years, it must have made a huge difference. The second thing where I think there's a huge problem which has been pointed out in the report is that when an accused is brought to the court, he doesn't have a lawyer. 84% or something you said don't have a lawyer. What actually happens is, and I've seen that because I had been practicing for quite some time in the Patiala House courts. What actually happens is that the accused is brought, he doesn't have a lawyer, all right, there are 3 or 4 cops around him, and the judge says, Acha, why didn't you represent him? So he's represented, his name is written over there, heard arguments, remanded to police custody for 10 days or remanded to judicial custody for 10 days. That lawyer is there as a name lender because he happens to be a legal aid lawyer. You know, so these are things which actually happen. I'm sure if you know, these issues are taken up, there will be a change. You know, I'm absolutely confident about it. And that's why I had said in my 4th point that I would certainly like organizations, whether they're universities, whether they're NGOs or anybody else, to carry out these kind of studies so that you know, things improve. It can't get worse. We need to focus more on the trial courts, you know, the magistrates or the sessions courts. I think we are concentrating far too much on the Supreme Court pendency, 60,000, 59,000, 61,000. It's all right, it's a problem. But when you compare it to, what, 2.5 crores in the trial courts, the kind of working conditions, library is the smallest of the problems. The problems in the trial courts are far, far greater than you can imagine. And I think it would be a good idea if law students are able to spend some time, you know, and the district courts, wherever they are. I mean, if they are on vacation, maybe in their own hometown, to see actually what's happening at the grassroots level. The second thing is that, you know, you had said about the judgments being unintelligible. I hope you're talking about the district courts and not the Supreme Court.
Significant difference between.
Okay. Now, you know, in many of the states, there is a requirement that you have to deliver a certain percentage of judgments in the regional language. Right? For example, in Maharashtra, you have to deliver at least 50% or 60% of the judgments in Marathi. In Madhya Pradesh, yeah, you have to have maybe 50-60%, maybe more in Hindi. Now, put yourself in the shoes of a judge who has to deliver a judgment not only in English but also in the regional language. There is a problem, you know, and well, you can say that English is not the first language. Perhaps that is a problem. But yes, I think we need to spend more time in the district courts. In fact, I had a discussion many years ago with Professor Madan about you know, internships that students do in the law schools, and his idea was that when you do an internship with an NGO, you're actually supposed to do it in a rural area, right? You're supposed to go to some village, taluka or whatever, and do your internship over there. But over the years, internship with an NGO has become internship with NHRC. It has become internship with some, you know, fancy organization. That's not what it is all about. And I think if we concentrate more on the district courts and the you know, courts of the magistrates, there will be a big difference.
Prolific British poet and story writer Joseph Rudyard Kipling, one of the first masters of short stories in English. In 1894 appeared his Jungle Book, which became a children's classic all over the world. Kim, the story of Kimball O'Hara and his adventures in the Himalayas, is perhaps his most felicitous work published. Set in and concerned with India he had come to know and love so well. In 1907, Kipling became the first English language writer to receive the Nobel Prize for Literature.
you get a feeling that the lawyers were missing, or at least they were not working for their clients.
You know, I'll take this from something that you said, which I have fully understood. When you say that it's not as though there is a bias against them because they are poor. In a system, the bias is that they are poor first, right? So if they are poor, then where they are represented, where they are tried, where they are, where the entire, the site where the drama takes place is affected by that deprivation, one. And there's hardly any reasoned analysis by which one comes to the conclusion that this is not how a lawyer must behave. The travesty is evident. I don't have to, dilate on it. Suffice it to say that the failure is at every level. The failure is at the level of the judiciary, which is unable to factor in this stark reality which stares it in the eyeball day after day. When it looks at a record, it must be evident that there has been no competent legal representation, and the class and social denomination of the person must also be evident, but this is clearly not factored into the sentence. Now, but even at the naming no names, I have seen a legal aid lawyer begin an argument in the Supreme Court for a death row prisoner, and for the first 25 minutes, one would have assumed that this was the prosecutor saying this has been recovered, and then this was then he disclosed this, then this was found. I mean, this is appalling. I have seen examinations under 313. The questions is just this. You have heard the evidence against yourself. Do you have anything to say? No. Well, that's it. So it's not, there's hardly anything which, my brilliance must illuminate to this gathering, that this is not the way either a lawyer must behave or a judge must behave. So that is the problem. The thing is, this is not factored in. We continue to have the most dire penalties dished out to the most disempowered people on the assumption that we have the rule of the law. The tragedy is that this is not factored in anywhere. When you say mitigating circumstances, aggravating circumstances, what can be a greater mitigation than deprivation of everything, including legal aid? But that is not factored in. That is a greater tragedy, really. Obviously, one of the most disturbing things that it brings out very starkly is the nature of the criminal justice system. Justice Lokur has given chapter and verse on it just now. I don't want to repeat what he said. But then it raises the most important question, which is, after all, the social compact is between the collective and the individual is that the individual cedes a certain part of her or his self on the count that there is a larger system of justice. If we are unable to be true to the very obligations that is the basis of this collective, then where is the justification to take life? Of course, an incidental question may be also, where is the justification to take away liberty? But what is remarkable about this report is it looks at the death penalty through the lens of the criminal justice system in an extremely pointed and relevant fashion. It's not just in broad strokes that the criminal justice system has failed or it's an irreversible punishment. It does not comment. It bears reality, both legal and sociological. As far as how prevalent torture or other violations may be in the process and how much they may have impacted the penalty, I think Volume 2 of the report is very, very clear in terms of what they have surveyed. It says the number of people, very, very high level, in fact, 136 out of 219 prisoners were not even informed of the grounds of arrest. Then, about the families, out of this, of course, I'm no read out, more than half of them were not produced before the magistrate. Out of 255 prisoners, 60 said they never received a copy of the charge sheet. The number of people, he says, 200 out of 270, 216 said that they had faced custodial torture. The number of people who were convicted based on a confession to a police officer, although that's strictly inadmissible in the case of most laws, is also significant according to the report, proven evidence. So information of this kind, all at one place, is truly remarkable. Confession to a judicial magistrate, and then of course the sentencing process. I would have liked to see a little more about how mercy petitions are dealt with, the lottery of mercy petitions, what are the factors that go into it, because so often you see, at least some of the reasoning that's reflected is, after all, the courts have upheld the penalty, so why should we interfere? I mean, the whole logic of this is because courts have upheld the penalty, that is why you go to the executive to see if there are other perspectives that can be brought to bear on it. Had the courts not imposed the penalty, there was no question of going to the executive to seek a mercy. So this kind of really daft begging the question that informs the process, aside from other factors of sheer callousness that Anup speaks about, that is something I would have liked to see in the report. Perhaps they could do it. I'm sure they will. There's something else which I don't know whether it can really be part of a report like this, because perhaps it takes us into the zone of the conjectural. But since you have, so starkly bared the anatomy of the penalty in this fashion, is it possible to get an assessment of what it does to the collective to have this penalty? Because as far as the individual is concerned, the failure of the criminal justice system, the psychological and sociological impact of this on the person concerned and the family, you're looking at it through, the focus is on the person who is at the receiving end of this penalty. But I would like to believe, in fact I do believe, that the collective also suffers. It adds to the volume of violence, it brutalizes the system to have this penalty. I mean, there is a cost to the collective, because even in debates, this is it is posed as, well, it's the individual, the pity for the individual, why pity for the criminal, and so on and so forth. I think that there is perhaps an answer to be had in what are the costs to the community itself, to the polity itself, to have a system coldly geared to extinguishing life. Whether that can be studied, whether that can be quantified, whether that can be assessed, I'm not very sure, but it is something that would be interesting. First, to confront the reality at every level, for lawyers to confront the reality, for judges to confront reality, and not to other the problem, saying the fault is there and the fault is there and the fault is there. The fault is all over. The fault, dear Brutus, etc., etc. Confronting it and, well, bringing to bear in whatever manner, wherever it is possible in that arena, around that arena. What is the way forward is just to go forward, I suppose. I don't know if that sounds facetious, but I mean, there's no this particular combination or that particular combination. If this is the reality, as we have known and we are now being told, then at every level to bring to bear upon the system some accountability. And, well, one thing really is, I don't think, we pay much attention to our the magisterial courts and the sessions courts, even when people come. This is something I suggested, for instance, to law schools, saying when each of you have 1 year where you send your students as interns to the magistrates court and just have a system so that there's a regular supply to those courts of this kind of energy. Because they're clearly also grappling with enormous pressures of work. They are not equipped with libraries. Many of them have, no access to, I don't know, maybe Delhi they do, but elsewhere perhaps they don't even know what they're supposed to do, what they ought, what they can do. So that infusion of energy is something really, such a remarkable report has been produced by NLU. I think the law schools must take this up as a challenge and, whatever, contribute to legal consciousness and legal education. I think educating the judges and the lawyers, as it were, I think they're sorely in need of it.